to Employment Law This Week. I'm George Whipple. Our top story, the EEOC files its first sexual orientation bias suits. Last year, the Equal Employment Opportunity Commission issued a determination that sexual orientation discrimination is a form of unlawful gender discrimination under Title VII of the Civil Rights Act. This month, the agency filed two landmark federal lawsuits seeking to enforce its interpretation of the statute for the first time. The agency is suing on behalf of workers at a company in Baltimore and one in Pittsburgh for harassment based on sexual orientation. Jeffrey Landis has more.
We anticipate we will see increased charges in this area as well as litigations, particularly in state and local jurisdictions where sexual orientation is not currently a protected classification. In order to best protect themselves in light of these lawsuits and insulate them from possible charges of sexual orientation bias, employers should take a look at their policies and procedures. Employers should consider adding sexual orientation as a protected status to their EEO policies. In addition, employers should consider expanding their training programs, particularly in jurisdictions where sexual orientation and gender identity are not protected categories under state and local law. It's also critical if employers are confronted with an internal complaint of sexual orientation discrimination or gender identity discrimination, that employers take these issues as seriously as they would a complaint of sex or race discrimination issues and investigate these complaints in the same manner.
The Ninth Circuit backs the DOL on tip pooling. In 2011, the Department of Labor issued a rule that barred restaurant and hospitality employers from including kitchen staff in tip pools, which are sometimes used to meet an employer's minimum wage requirements. The DOL ruled that kitchen staff should be excluded from pools, even if the tips are not required to meet minimum wage obligations. Two district court decisions held that the department does not have the authority to regulate this practice outside of the minimum wage issue. But the Ninth Circuit recently reversed those decisions and upheld the department's rule. And more from the Ninth Circuit this week. The court took a broad view of successor liability in a recent pension case from California. Studer's floor covering had an agreement with the union that the company would contribute to the Resilient Floor Covering Pension Trust Fund for employees. When Studer's went out of business, a former staffer with the company started Michael's Floor Covering, leasing the same store and warehouse that Studer's had used. The pension fund believed Michael's was a successor to Studer's and sued Michael's for more than $2 million in withdrawal liability. The Ninth Circuit found that an asset purchaser can be liable as a successor under the Multi-Employer Pension Plan Amendments Act and remanded the case to the district court, instructing it to look at the successorship factors again. A Massachusetts court rules former counsel is not barred from giving advice to a competitor. An in-house lawyer for Gillette left the company 10 years ago. 4 years later, he became general counsel for Shave Logic, a Gillette competitor. Gillette recently tried to obtain a broad injunction against the lawyer, who they claimed would inevitably disclose trade secrets in his position. The Massachusetts Superior Court Business Litigation Session ruled that there was insufficient evidence that trade secrets would be revealed, and any knowledge the counsel had of patents was likely outdated or general knowledge. The NLRB orders Dish Network to adjust its solicitation in the workplace policy. The NLRB held that a call center worker was terminated in violation of the National Labor Relations Act for soliciting co-workers to join a lawsuit alleging his employer made unlawful wage deductions. The company had a policy prohibiting solicitation in the workplace even during non-work time without the approval of management. However, the NLRB stated that the company could not ban solicitation during non-working time and could not require employees to obtain management approval before they could engage in concerted activities relating to terms and conditions of employment. The NLRB ruled that Dish Network must alter its solicitation policy. That's it for Employment Law This Week. Thank you all very much for watching, and we'll see you next time.